Hello everyone!
Hello, welcome to MyData-NEWS.
Welcome back, yes, for more interesting news of this month. So let's start.
So let's go with the life sciences section. So at the end of April, the European Commission published an updated version of its Q&A on the EU clinical trial regulation, the CTR. The CTR repealed and replaced the clinical trial directive as from the 31 January 2022. But however, the CTD will continue to apply until the end of 2025 to clinical trial applications submitted before January 2022 and clinical trial application submitted between January 2022 and January 2023, in which the sponsor opts for the CTD system. So, example of question updated. So, what documents or data should be submitted with an application, or how to process in case of discrepancy between the CTR and the ICH Good Clinical Practice Guidance, and a last one, what are the consequences of switching the regulatory framework applicable to a clinical trial.
On May 3rd, 2022, the European Commission proposed a regulation to set up the European health data space, furthering its pursuit for a single market for digital health services and products. And it is one of a number of laws that have been introduced in recent years under the European Commission's Data Strategy Initiative, but the first common data space to be introduced. And the health data space is to be set a health-specific ecosystem comprised of rules, common standards and practices, infrastructures, and a governance framework.
Another news regarding the life sciences, the Spanish Data Protection Authority, the AEPD, added on the beginning of May 2022 a new section under the Areas of Action section of its portal relating to health and data protection. In particular, the new section comprises 6 subsections, and the first subsection outlines rights in relation to health data, explaining the regime under the Article 9 of the GDPR, and also how to exercise the right of access, which regulates basic patient autonomy and right and obligation in terms of information and clinical documentation, and how a claim can be submitted to the Data Protection Authority in case where the right of access is denied, the retention of clinical histories, and the limitation to the right of deletion.
And now some interesting news about data protection. So the Commission welcomes the swift political agreement reached this month between the European Parliament and EU member states on the proposal on the Digital Services Act, we called DSA, proposed by the Commission in December 2020. And the DSA sets out an unprecedented new standard for the accountability of online platforms regarding illegal and harmful content. And it will provide better protection for internet users and their fundamental rights, as well as define a single set of rules in the internal market, helping smaller platforms to scale up.
Another news regarding the European Data Protection Supervisor, the EDPS, who announced at the beginning of May that it had jointly with the European Data Protection Board, the EDPB, published and adopted its opinion on the proposal of the European Parliament and of the Council on harmonized rules on fair access to use and use of data, the Data Act, and in particular the EDPS noted that along with the EDPB, welcome the efforts made to ensure that the Data Act does not affect the current data protection framework, and at the same time, since the Data Act will also apply to highly sensitive personal data, the EDPS and EDPB urge the co-legislator to ensure that data subject rights are duly protected. And furthermore, the EDPS noted that the access, use and sharing of personal data by entities other than that data subject should occur in full compliance with all data protection principles and rules, and also highlighted that products should be designed in such a way that data subjects are offered the possibility to use devices anonymously or in the least privacy intrusive way possible.
The European Data Protection Board, EDPB, has just published its guidelines on the calculation of administrative fines under the GDPR, harmonizing the methodology data protection authorities use. So the guidelines include harmonized starting points for the calculation of a fine. There is 3 elements actually to be considered: the categorization of infringements by nature, the seriousness of the infringement, and the turnover of a business. And the EDPB chair, Andrea Jelinek, said that from now, DPAs across the EEA will follow the same methodology to calculate fines. And this will boost further harmonization and transparency of the fining practices of the DPAs.
Thank you. I continue with the news regarding Meta. So Meta was back in the court in Luxembourg, this time arguing that Germany's competition watchdog has conflated competition and privacy legislation. The case hinged on the use of Facebook plugin on third-party websites and applications via like and share buttons, and the accumulation of data through Facebook Business Tool and Facebook Analytics.
In the UK, the Department for Digital Culture, Media and Sport, DCMS, has proposed a code of practice to set minimum privacy requirements for App Store operators and developers, and is asking for feedback. So the aim is to increase security and privacy requirements for app operators and developers. And one proposal is that apps would need to explain why it needs access to users' contacts or location, and the consultation runs until the end of June. And depending on the feedback, the code could be issued later this year.
Thank you, very interesting. I continue with Japan. The Ministry of Internal Affairs and Communications, the MIC, announced that it had launched a digital partnership with the EU. And in particular, the MIC detailed that both sides recognize the importance of data transfer, noting that technologies for enhancing trust are essential to achieve the free flow of data with trust across borders.
Thank you. In middle of May 2022, the Future of Privacy Forum launched a comprehensive report analyzing case law under the GDPR applied to real-life cases involving automated decision-making. And this report is informed by extensive research covering more than 70 court judgments, decisions from data protection authorities, specific guidance, and other policy documents issued by regulators.
At the end of May, the European Commission published guidance outlining question and answer (Q&A) on the 2 sets of standard clauses on controller and processor and third country data transfer, respectively, as adopted by the European Commission 1 year ago, in June 2021. In particular, the Q&A aims to provide practical guidance on the use of the SCCs to assist companies with their compliance efforts, and is based on feedback received from various stakeholders on their experience with using the new SECs in the first months after the adoption.
The 25th of May marks actually 4 years since the entry into effect of the GDPR, and data protection authorities from the EU have been reflecting and looking back on the past few years. And in particular, a number of authorities have issued activity summaries and statistical highlights to mark the occasion. For example, since 25 of May 2018, the Hellenic Data Protection Authority has received more than 4,000 complaints, 2,055 of which have already been handled, and 1,700 are currently under examination. And that is as issued fines totaling 11,000 euros. And in Cyprus, the Office of the Commissioner for Personal Data Protection has handled more than 1,500 complaints, 415 of which are concerned and went in direct marketing, and 305 data breach notification, and 74 data protection impact assessment called DPA, and initiated 425 investigations.
A lot of numbers.
Yeah.
So in Hong Kong, the Privacy Commissioner for Personal Data, the PCPD, published at the beginning of May its guidance on recommended model contractual clauses for cross-border transfer of personal data. The two sets of recommended model contractual clauses gather for two different scenarios in cross-border data transfers. The first one is from one data user to another data user, and the second one is from a data user to a data processor. So the model clauses may be adapted by organization, especially like small and medium-sized enterprise, and as the section 33 of the Privacy Ordinance, which imposed restriction on cross-border transfer of data, is not yet in effect. This guidance recommends best practices to be adopted. But the DPA says that, however, that is it advisable for organizations to incorporate the RMSC into cross-border data transfer, and as their adoption will illustrate that the data controller has taken all reasonable precaution and exercised all due diligence, the DPA will take this into account when considering enforcement action.
A new study shows that 97% of the most popular websites use dark patterns and not just cookie banners, actually. So, in an analysis for the EU Commission, researchers sound the alarm because design tricks and other unfair business practices are actually on the rise of internet. And in the digital environment, there are more and more efficient artificial advertising measures that attract consumer attention and induce them to make business decisions that may run counter to their interest. So this is the conclusion reached by researchers in a study on psycho-design tricks, such as dark patterns and manipulative personalization commissioned by the EU Commission. And in fact, unfair business practices such as dark patterns can jeopardize consumer trust in digital markets and exploit consumer vulnerabilities, according to the analysis now published.
After that, a highly unusual decision by the Belgian Data Protection Authority was published at the beginning of the month on cookies. Why unusual? It's part of a broad investigation, and many of the other targets are still awaiting a hearing on the case, which suggests that the Belgian DPA wished to prioritize one case and get one decision, and in turn raises the question as to whether the Belgian Data Protection Authority has already decided the outcome of the other cases even before hearing the parties. So the case in a few points. So the inspection service considered that only a few of the cookies detected were strictly necessary, and the defendant doesn't appear to have put forward any justification of the necessity of the others. And the Belgian Data Protection Authority reiterates its view that statistical cookies still enable identification through the use of IP addresses on other identifiers, and it goes on to the stress that the IP addresses are personal data.
And more about cookies, CNIL recently published assessment criteria for website cookie walls and provide that, for example, you must demonstrate that there is a real and fair alternative to access the content, that requiring payment as an alternative is not prohibited per se but needs to be reasonable as determined on a case-by-case basis. Also, to consider non-traditional forms of payment such as micropayment of a virtual wallet. If you require the creation of a user account, you have to ensure that this is justified in relation to the intended purpose. Also, a cookie wall can't systematically impose acceptance of all trackers on the website. And finally, if the user chooses a paid access, you need to ask, can you pay deposit any cookies anyway? And yes, you can, but this has to be very limited.
Thank you. So I continue with Twitter. Twitter has agreed to pay 1,050 million fine to settle the Federal Trade Commission allegations that it entices consumers into sharing personal information under false pretenses. So Twitter began asking people to provide emails and phone number in 2013, explaining that the information will help them reset accounts or enable two-factor authentication. But however, over the years, the company used those email addresses and phone numbers as identifiers, sharing them with media agencies and ad networks to create audiences for online advertising. When companies tell consumers they will use data for certain reasons and later use it for other reasons, it's called secondary use. And it's frowned upon by regulators around the globe. So regulators insist on purpose limitation, meaning that companies should only use personal data for the purposes that were described to the consumer at or before the time the data was collected or used. And a new purpose that is very closely related to the original purpose may be acceptable, but it is a gray area that requires careful legal judgment.
The potential overturn of Roe versus Wade has triggered an important debate about privacy for people using fertility and menstruation tracking apps. This is in the US and beyond. So not only privacy, but also data protection, security, safety, and abortion rights are crucially implied in this debate. And after the Supreme Court leaked decision, some call for people to delete their period tracking apps due to the concerns that could be entailed from the data they collect. So fertility and menstruation tracking apps data, for instance, could potentially be used as evidence against someone suspected of having an abortion in the US.
Thank you. As it occasionally does, the company formerly known as Facebook has produced a new revision of its terms of service and update its privacy policy. So the old Facebook data policy is now Meta's privacy policy, rewritten to make it easier to understand and to reflect the latest products. So with this revision, Meta is not collecting, using or sharing your data in new ways based on this policy update, and we still doesn't sell your information according to the company. Instead, this update tweaks the language and adds examples to help people understand what each segment is about. And after reading through the new policy and comparing it to the old one, these appear to hold up for better or worse. The senior counsel for the Electronic Privacy Information Center said that the promise that this policy won't share data in new ways sounds good, but the problem is that Facebook already funnels user data and at industrial scales into a vast targeted advertising ecosystem. So the status quo is not good for privacy.
And now more news about the legislation. So Connecticut became the 5th US state to pass a comprehensive privacy law with pending signature of the governor. So this bill is generally based on the Colorado Privacy Act. It is stronger than Virginia's VCDPA and obviously the Utah Consumer Privacy Act. So the opt-out requirements are actually more strong. Like Colorado, the bill will require controllers to recognize opt-out signals, but unlike Colorado, opt-outs will not need to be authenticated. So there is a right to cure also, but it will sunset. And once it does, Connecticut will be positioned to join California and Colorado in multi-state enforcement actions for violation of comparable provisions. The consent provisions are similar to Colorado and Virginia. For example, consumer consent is required to process sensitive data. However, Connecticut also requires controllers to allow consumers to revoke their consent. And the bill goes further than Colorado, Virginia, and Utah on children's data privacy rights, mirroring California's requirements.
I continue with the Philippines. The National Privacy Commission, the NPC, announced the launch of the new Data Breach Notification Management System, the DBNMS. In particular, the NPC highlighted that the DBNMS provides for submission of personal data breach notifications and annual security incident reports. And more specifically, the NPC outlined the DBNMS provides for the submission of data breach notification by personal information controllers. In addition, the Commission noted that the new system allows for greater transparency by allowing the personal information controller to access information on their data breach notification. And furthermore, the Commission outlined that the controller, which are part of a larger group with other related companies or entities, must register as a separate account under the DBMS in order to submit data breach notification.
In Brazil, the Data Protection Authority, ANPD, issued an official clarification note stating that it was made aware of the publication of an ordinance authorizing the Federal Service for Data Processing to provide third parties with access to data subjects' personal data held by the Federal Revenue Service of Brazil. So in particular, this ordinance addresses topics such as the cost of maintaining the electronic system required to enable access to personal data, assuring the execution of a risk identification process for the institution or a risk to confidentiality. And as a result of that, the ANPD announced that it has begun an administrative inspection process in accordance with the authority's prerogative to ensure the protection of personal data and will verify the adequacy of the General Personal Data Protection Law, the LGPD.
In Dubai, the Dubai International Financial Center issued a consultation paper seeking public comments on its proposal to issue updated guidance materials regarding the proposed Ethical Data Management Index research and methodology, the standard contractual clauses, and the updated data export and sharing handbook regarding obligation, under the Article 28 of the DIFC Data Protection Law. And in particular, this financial center highlighted that the EDMRI is the Office of the Commissioner's own risk index to guide companies in determining additional, enhanced due diligence and contractual requirements that should be implemented when processing personal data in a specific environment.
At the beginning of the month, the Prince of Wales delivered the Her Majesty's Most Gracious Speech to both Houses of Parliament, and which contained 38 bills intended to be passed in the coming year, including the Data Reform Bill, and specifically the Prince of Wales stated that we will create a first-rate data rights regime and the UK's data protection regime will be reformed.
In Thailand, the Personal Data Protection Act was initially intended to take into effect in May 2020, but encountered two separate postponements due to the pandemic. The PDPA will come into force on June 2022 and is expected to bring the first consolidated legislation providing general data protection within Thailand.
In Russia, the state parliament announced on May 24, 2022, a bill amending federal law of July 26 on personal data that was adopted at first reading. And in particular, the Duma, so the state parliament, highlighted that the amendments require data operators to immediately report all cyber attacks and data breaches to relevant authorities. In addition to that, the Duma outlined that data operators will be required to inform relevant authorities of the intention to transfer personal data to third countries, and that such transfer may be limited, dependent on threats to defense and national security.
And the last news for today, in Moldova, the National Center for Personal Data Protection announced that it has published in the official Gazette of the Republic of Moldova on the approval of standard contracts for the cross-border transfer of personal data to states that do not provide an adequate level of personal information data protection level. So thank you very much. Do not hesitate to continue to follow us on the different social media. So we are on LinkedIn, on YouTube, and on Twitch.
Thank you, everyone, and
Thank
see you
you
next month for more news. Bye-bye. Thank you.